You can follow every gun law in your state, do everything right, and you still commit a federal felony, not because of what you do, but because of where you are. Walk past a school, drive down a street, stand in front of your house that happens to sit within 1,000 feet of a school, and suddenly you've crossed a federal line most people don't even know exists. Your common sense would tell you you're safe. The letter of the law says you're not. And the space between those two is where good people get into trouble. I'm Tonmiel Rodriguez, a Florida board certified criminal trial lawyer. In my last video about open carry in cars, which you can watch here, we discussed the Gun-Free School Zones Act and how it applies to open carry in cars. A lot of you ask great follow-up questions like, what if my house is in a school zone? What if I walk or drive through one with no intention of stopping? What if I just drop somebody off? Can I really be prosecuted for this? This video is my response to those questions. And where some of you may find that the strict letter of the law and common sense part ways. We'll look at 5 scenarios based on your questions and how the law applies to them. And we'll discuss a real case, United States versus Metcalf, where a homeowner was charged and convicted for doing something most people would call reasonable. So let's dive in. The Gun-Free School Zones Act is found at 18 U.S.C. Section 922 Q. It's a federal law, meaning it applies above and beyond any state law regulating firearms. It makes it a felony for any individual knowingly to possess a firearm at a place the individual knows or has reasonable cause to believe is a school zone. A school zone is defined as in or on the grounds of a public, parochial, or private school, and within 1,000 feet of that school's property line. That's 1,000 feet as the crow flies, in every direction. Not just a school building and its property, but sidewalks, streets, and neighborhoods around it. Knowingly means you're aware you have a firearm on you. So, no bad intent or evil purpose behind that possession is required. No threatening conduct is required, just possession. You must also know or have reasonable cause to believe you're in a school zone. That offers some protection. In United States versus Guzman Montañez, a conviction was overturned on appeal because although the school was within 1,000 feet, prosecutors failed to prove that the defendant knew or should have known that fact. Evidence of proximity, meaning him being close by, is not enough. But this is rare. There's usually a school sign, there's a playground or other indicator, and the prosecution is usually smart enough to present testimony to demonstrate how the defendant knew or should have known it was a school zone. And that's all it takes to show knowledge. Common sense may say, if I didn't know, I can't be guilty. Federal law says, if you should have known, that's enough. Now, here's where you get some relief. Congress built in a few exceptions. An exception means that the law doesn't really apply to you if you fulfill certain conditions. These are your legal safe harbors. In other words, if you meet one of these conditions, you're not violating the law, even if you're inside that 1,000-foot radius. So let's start with the private property exception. If you're on private property that's not part of school grounds, your home, your yard, your driveway, you're covered. Once you step off your property onto a public sidewalk or street, you are exposed, unless you're licensed to carry in Florida. Why? Because there's a license to carry exception. If you have a valid state of Florida issued concealed carry permit, you're covered. This is one of the reasons to still get your permit. Then there's the unloaded and locked exception. If your firearm is unloaded, no bullets in it, and locked in a container or a gun rack on a motor vehicle, you're covered, even without a concealed carry permit. This is the safest way to travel through a school zone. So these are your lifelines, the difference between lawful possession and a felony. There are a few other exceptions, like exceptions for law enforcement and certain school programs that are beyond the scope of our discussion. But here's the catch. These exceptions only protect you if you're inside of them. You step outside, even briefly, and you're rolling the dice. To illustrate this, let's go over the 5 scenarios I came up with based on your comments and questions. Take Sally. She lives across the street from an elementary school. She takes evening walks with her firearm holstered on her hip. Once she steps off her driveway and onto the sidewalk, she's within the 1,000-foot school zone. So unless she has a valid license to carry or her firearm is unloaded and locked, she's technically violating federal law. Would she be prosecuted? This would depend on many factors, including being discovered. So perhaps not. But nothing in the law prevents it. All it takes is one call about a woman with a gun near school for things to escalate. Now take John. John's backyard fence borders the high school baseball field. He walks the fence line with his firearm. As long as he stays on his property, he's fine. One step beyond that fence, and he's not. Would a prosecutor pursue it? Again, that depends on the circumstances, including how and why police got involved in the first place. So probably not. But the law wouldn't prevent his prosecution if he stepped over the line armed. If John takes that risk, he's leaving his freedom up to chance. Here's Mike. Mike's only route to work passes a middle school. His loaded handgun is in the center console. But here's the catch. There is no "this is the only route available" exception. He either needs a qualifying license or he must keep the gun unloaded and locked. Without that, he's committing a technical violation every morning. And if he stopped for speeding, that small discovery could become a federal case. It may never happen. But does he want to roll the dice? Now take Maria. She's driving home with a loaded handgun in her glove box. She passes a school, doesn't stop, but just drives through. She has no intention to stop. But intent doesn't matter. Location, presence, and possession matters. If she doesn't meet an exception, she's technically in violation, even if she never set foot on the school property. She may never face prosecution for any number of reasons. For example, she may never be caught in the act. Prosecutorial discretion may save her, even if she were to get caught. But the letter of the law is clear, and prosecutorial discretion is not always predictable, and certainly is always circumstantial. And here we have Daniel, a rideshare driver. Daniel drives for a rideshare app. He keeps a firearm in his car for protection. Every time he drops off a passenger at a school, he's within the 1,000-foot zone. If he doesn't have a qualifying license or keep his firearm unloaded and locked, he's committing a technical violation over and over again. And again, whether he's ever charged depends on two things: discovery and discretion. For those of you who doubt that prosecution under the Gun-Free School Zones Act actually does happen, take the case of United States versus Metcalf. Metcalf lived across the street from a public school in Montana. He had a valid license to carry issued by the state of Montana. One day, he carried his firearm while standing outside his home, just in case he needed to protect his mom from a neighbor that had threatened her. He didn't use a firearm. He didn't threaten or harass anyone with it. He just carried it. He never entered school property. But some neighbors were concerned and called police. He was ultimately charged under the Gun-Free School Zones Act, even though he had a valid Montana license, and arguably fell under that exception. Why? Because the federal prosecutor believed Montana's licensing scheme did not meet the federal requirements. He was convicted by a jury, and then he appealed. The Ninth Circuit Court of Appeals reversed his conviction, finding that he was in fact covered by the license to carry exception because he had no reason to know that Montana's unique licensing process did not meet federal requirements. So Metcalf ultimately won, but only after being convicted and fighting through appeals. The exception saved him from a permanent record, but not from the ordeal. So when does this law actually get enforced? The short answer: whenever they choose to. If possession, proximity, and lack of exception are proven, the case is chargeable. Whether it's actually charged depends on discretion. What you do see is that this crime is often accompanied by other offenses. So it's tacked on by federal prosecutors, perhaps as a negotiating tactic for leverage. Or you may see it charged in situations where no state law clearly criminalizes the person's behavior, like a weird person camping out near a school with a firearm in his vehicle. But he happens to be within 1,000 feet of a school while armed, causing concerns to citizens. And so authorities can get the person off the street on that basis, where they would not have been able to get them off the street otherwise. So context matters. Visible firearm, complaint, public safety concern. But the reality is that you can't control prosecutorial discretion. You can only control your behavior and whether you stay under an exception. So bottom line, if you live near a school, know where that 1,000-foot line is. If you drive through one, either have a qualifying license or make sure your firearm is unloaded and locked. You can live inside the exceptions, or you can live on luck, but you can't live on both. Metcalf proves that even a responsible gun owner can become a test case. He was lucky. Others may not be. Where the letter of the law is clear, the real-world application is often unpredictable. And when those two collide, law enforcement usually wins, even if you win later on appeal. If you want to take the uncertainty out of it, follow an exception every single time. I'm Tonmiel Rodriguez, a Florida board-certified criminal trial lawyer. If you found this video helpful, please like, please subscribe, and share it with somebody who needs to know. Thanks for watching, and I'll see you in the next one.